Welcome to Brutal Honesty with author, teacher, and national trial lawyer, Nick Rowley.
Hey, Nick, how you doing?
Good, brother.
Who we here with today?
Have my partner, John Kawai, and partner, Grayson Yoder.
We're here actually a little bit over 30 years after the first hot coffee case that really got our culture thinking, and not only about lawsuits, but who pursues lawsuits, what kind of lawsuits do they pursue? And here we are again. That was a $2.9 million verdict in 1994. When I looked today, it looked like there's thousands of people that are telling this story all over again. How are we here again 30 years later?
I think there have been a lot of cases in between then and now that were legitimate, meritorious cases. Not many that have been either successfully resolved, and none that I'm aware of that were successfully tried to a jury. There is such a stigma, or there has been up until now, about a hot coffee or a hot coffee case, where when we're picking a jury and we're talking to people, right? They go right to the hot coffee case. Well, you remember that hot coffee case, where that woman got millions of dollars, but they know nothing about the case. And yet they have this opinion that's been stuck in their brain, this attitude, this belief, this bias that they've held on to. The question is, where did it come from? Where it came from is it came from propaganda in the defense industry, putting a spin on that McDonald's hot coffee case back in 1994, back when there was no social media, back when, one story could go viral within news outlets, and where the power structure, which was corporate America at the time, that was, anti-lawsuit, as corporate America always is, because corporate America doesn't want to be held accountable. So they want to have laws passed, and they want to do things to insulate themselves as much as possible from liability. They control the narrative. And now we control the narrative with the truth. And a jury trial that was actually recorded, gavel to gavel, from beginning to end by Courtview Network. So everybody in the world can look and see that this is a meritorious case. This is a case where the jury made the right decision. And anybody who questions that, all they have to do is go and watch the evidence that the jurors saw, because it's all there for everybody to see. And the news outlets, not just in the United States, but all throughout the world, is now looking at this evidence and saying, wow, Starbucks really messed up. Starbucks really maimed, severely injured a man, changed his life completely, destroyed his penis, inflicted, severe PTSD onto him, changed his brain, because that's what PTSD does, and frivolously denied liability, and got busted, got hit hard with the verdict that Starbucks deserves to get hit with. And now the whole world knows it, and the whole world knows that not just Starbucks, but most of those out there in the coffee industry have a very frivolous and dangerous policy, which is, if I hand you a drink, no matter how I hand it over to you, whether the lid's on or not, whether it's pushed down and seated correctly in the drink, the container, the holder, the tray or not, if my hands are off that drink at the time that it spills, no matter how I handed it over to you, I, the corporation, I, the coffee shop, am not responsible. It's your fault. And that's Starbucks policy, or it was until now.
And we're going to get to the policy, and we do want to transition, but it's worth still talking about this 1994. What we knew about McDonald's then, there's 700 complaints about this. Nothing was done about it.
Right.
They keep going. The plaintiff was mocked in such a way that the Stella Awards were created to make fun of frivolous lawsuits when it wasn't. It took until 2011 for the documentary Hot Coffee to finally come out and start teaching people. And now you're ahead of the game on that. So let's break it down with your team.
Sure.
Because this isn't a case that you got 6 months ago. You're popular sometimes for coming in 10 days out, 1 day out, 2 weeks out. Your team had this case for a long time, correct?
Few years.
So let's talk about that. And then I think this is some of the questions we'll get to later, but what are the hurdles you're dealing with? You have this type of case. What were the first hurdles that you guys started seeing going up against a corporation like Starbucks?
Well, first of all, Starbucks hid the evidence. There was a surveillance video that Starbucks had and denied having. So Starbucks knew exactly what happened. Starbucks knew that its employee didn't seat the drink properly and handed over a burn to a customer, and not just a customer, but a Postmates driver who's actually providing a service for Starbucks. Starbucks is making $1 billion plus per year off of drivers, that are working for Postmates and DoorDash and Uber Eats. So they injured one of their own, if you will, one of the middlemen. They're one of the vehicles to their profit margin. And they knew it, but they hid the evidence and blamed him. So that was tough. We had to fight, and we had to go into court and compel them, force them to turn over the video surveillance that they denied having.
Because a lot of people don't know, hey, when are they telling the truth and the video's gone or doesn't exist? You start to piece together, they have a video, they should have had a video, and they had it. Talk to the folks that are listening a little bit more about how you go get that.
They always have a video. If somebody came in and robbed Starbucks, they'd produce that video right away. But it is the corporate policy, based upon what I've seen, not just in this case, but other cases, it is the corporate policy to deny having a video. And maybe to go in and delete whatever video footage there is, if it's incriminating. That's an awful corporate policy to have. But I've seen it with Starbucks, and I've seen it with other corporations.
When you talk about that kind of policy, Nick, were those things you actually found in writing, or was that the practice of this corporation that knew they had to cover up the evidence?
It's not in writing, but the proof is in the pudding. You look at the way they behave, and you send out a request for video surveillance, and they say, we don't have any. And I've seen that over and over and over again.
And John, were you out there slugging away at some of these arguments as you're fighting over some of this discovery stuff? When the case came into us, we have to give a lot of credit to people like Ken Shai and Michael Parker, who did the initial motions to compel and had to really deal with what I feel were, not fair rulings from the judge that they were dealing with at the time. But even after that video was produced, we found out later that there were other, potentially other angles as late as, putting together our exhibits for pretrial documents, things like that. So Grayson took a lot of the laboring oar in terms of finding out exactly what was concealed, whether terminating sanctions were on the table. But it turns out that those other things, while they should have been disclosed earlier, really didn't show the incident. So we were able to proceed with trial and things like that.
There was footage and other surveillance that they withheld that we didn't find out about until right before trial.
Correct. And not only that, but we took depositions of the barista who was there, who claimed that she didn't remember anything that happened.
Right.
We took, we tried to get policies, we tried to get procedures at every stage. They had coached, apparently, their witnesses to say either they don't remember what the policies were, they don't remember anything about this incident happening. I mean, you look at her face in that video and you would think she would have been traumatized.
Absolutely.
Right?
She absolutely remembered. But, after a bunch of time with corporate, big corporate defense lawyers, these witnesses all of a sudden have the memory of an Alzheimer's patient. They don't remember anything, but we've seen that over and over again when we're bringing cases against big corporations. They coach, they intimidate, and they dumb down their witnesses.
Right now, you're talking about witness school and what we've been seeing a trend both in med-mal and all other
absolutely
areas where for some of these people, it might be one of the most memorable things that have ever happened to them. Mm-hmm. And all of a sudden they have no memory of it.
They forget.
So before we move on to the actual trial, which is coming up after this, you talked about policies, Nick. You talked about what they want to cover up. Let's talk about liminal motions. And people like to hear, what was the defense fighting to keep out and what did they successfully keep out?
What Starbucks was hoping to do was get evidence in front of the jury that was really fake evidence. About 2.5 weeks after this bad thing happened to Michael, Starbucks did an investigation and they created these false witness statements. And so the defense attorney was, I think, hanging his hat on expecting to get this report that Starbucks put together into evidence in front of the jury as a business record, thinking that it was an exception to the hearsay rule, which it absolutely is not. So in a jury trial, if we call a witness, you get to cross-examine that witness if you're our opponent. If you call a witness, we get to cross-examine that witness. It's a constitutional fundamental right. So Starbucks was trying to get around that constitutional right, that rule, and present witness statements that were taken after the fact that were absolutely false and made up, like blaming Michael dog for causing the spill, which the video shows his dog had nothing to do with it. He had a puppy in the car, but the puppy wasn't anywhere near, where the spill occurred. And they were expecting to get that into evidence. Maybe because there are a lot of judges out there that are going to let that evidence in to help the corporation. Sadly, there are a lot of great judges out there, but there are also corporate defense lawyers in black robes who call themselves judges, who we have to stand before, who make rulings every day that hurt us, that hurt people. And maybe Starbucks was banking on that, but it didn't fly because we had a good, honest judge who understood the rules of evidence. So they didn't get to do what they thought they were going to be able to do.
Well, now that we're at trial, let's talk about the bifurcating.
Sure.
A lot of people have thought about bifurcating a trial, either voluntarily or trying to get the defense to. How did we end up with a bifurcated trial? Was that something you pushed for, or did the court order, or what happened?
Yeah, we pushed for it. Whenever there is a dispute in a liability case, we believe in bifurcating. Let's have the jurors focus on who's responsible, on what went wrong, on whether there is or is not negligence. We don't need to gild the lily or get jurors to, feel sympathetic about a person's injuries in order to win liability. Only lawyers who aren't good enough need to do that. And oftentimes it backfires and it doesn't work if jurors are actually doing their job. So if a defendant wants to frivolously dispute liability, we say, all right, let's go try liability. And we'll beat your ass on that, and then we'll go to damages, which is exactly what we did.
Well, let's go back, Nick, because you've done it a few times. What advice, if someone has their whole caseload, they're trying to figure out, when does this make sense? And I understand what you just said. What advice could you give them where they actually go fight for the bifurcation? And what might be some more things you consider?
Well, if you're going to lose the case on liability, if you're not going to win your negligence case, then why do you want to put your client, the person who you're representing, on the stand to, spill their guts and talk about all these awful things that they've been through, when you could actually save them from that? If you can't win your liability case, then why are you going to put a vulnerable, damaged person up and have them talk to a whole bunch of strangers about the most intimate details in their life and then get zeroed out, get nothing? Why are you going to call a bunch of expert witnesses that you have to pay a whole lot of money to if you're going to lose the case on liability? If you can't win your case on liability in a bifurcated trial, then you shouldn't be trying the case. So you save time, you save money. That's one way to look at it. Other way to look at it is you get the jurors to focus. And then when you try the damages case, you're just focusing on damages. What are the injuries? What are the damages? And what's it all worth and why? You don't have liability now bleeding into the damages case. You don't have jurors who might want to, assess some comparative fault against your client. Maybe say, Michael was 10 or 15% at fault, and they lose that. So now they're going to lower the damages, right? And they're going to change their votes and try to negotiate and compromise the verdict because they're upset about what the rest of the jury is doing on the liability questions. Think about it. You get to just separate it out. Liability is liability, then damages are damages. And you get to tell the jurors when the damages phase starts, you can say, hey, what happened in the liability phase is over. Now the only question is, what's it worth?
I want to talk about when any crucial moments when you think there was a shift in momentum in your favor.
I would say that it was an opening, and the reason for that. And the other thing I'd say on bifurcation is that we had a video that showed the negligent act, clear as day. And so we kind of knew we were going to be able to prevail on liability. It was a matter of, would Starbucks be able to squeak in some type of contributory negligence? And in Nick's opening, he played the video, he showed the frames, he showed what we'd showed the focus groups, he showed what we'd all believed in for the last 4 or 5 years. And sitting there, I was like, this is a done deal. And then for the rest of that liability stage of the trial, Starbucks just used up any credibility that they may have had with the jury. And so they were left with nothing for damages.
There were some things in this trial that I had not seen before. And one was that the defense was actually putting exhibits in their mini opening. And so they basically put out what they thought their best evidence was, and they put it all in the mini opening. And so the opening was actually a chance for us to do some rebuttal. So when they've shown, little snippets of the video, and, obviously if you look at the video one time from one angle, it may not really be clear what's going on. But when you take the time to walk the jury through the video, show stills of the important moments, zoom in on the important aspects, the liability case, falls into place pretty naturally. And I feel like, from the get-go, the defense having shown some clips, not showing necessarily what was relevant, I think that hurt their credibility. And it sort of had to be sort of, it was emphasized repeatedly through various witnesses to the unreasonableness of the position they were taking.
The mini opening statement that the defense was ready to do with these slides, the judge was going to shut it down. They tried to win their case in the mini opening statement. We did not. Strategically, the case we just tried that, we just got paid, $35 million on, right before that, the case we tried against Dana Fox and Michael Schoenbuck and Eddie Ward, that case, we went for it in the mini opening. This case, it was different because of the public perception and the stigma that attaches to a, hot coffee case. We're just going to tell the jurors that we're looking for fair people. There's some things we want you to know. This is a case where a hot coffee drink was spilled. It was actually a hot tea, a medicine ball, about 180 degrees, involved some bad injuries to a man's penis. And we're going to be talking about tens of millions of dollars in damages. Made it very, very simple and told the jurors that what we needed was a fair and impartial jury. And if there are people that had opinions or, beliefs or attitudes about, hot coffee cases or the McDonald's hot coffee case, and the just hearing about this type of case just rubs them the wrong way and they have a bias and they can't be fair, to please have the integrity to tell us. That was really our mini opening statement where the defense got up and they tried to win. So that actually allowed me all throughout jury selection, and jury selection took a few days, to actually address all of those issues and all of the issues that, like the dog, for example, in the defense's mini opening statement, they're like, and he had a dog in the car. Well, then a bunch of jurors, potential jurors, were riled up. Well, it must have been his fault since he had a dog in the car. So during, jury selection at one point, there was another juror that was all riled up about the dog. And he said, he goes, well, I think it's probably his fault because he had a dog in the car. And I said, I want you to assume something. This is during jury selection. I want you to assume that there wasn't just one dog in the car, there were 5. And they're all barking. One of the dogs is farting. Another dog is like chewing on the other one's ear. I mean, it's just chaos in that car. But there's a video, and the video shows that those dogs had nothing to do with the coffee spilling. Do you still think he should be held responsible because he has dogs in the car? If the dogs didn't have anything to do with the drink spilling on his lap? And the juror looked at me like this. Okay, you got to go.
Nick, on the momentum issue, to end with you on this topic, people look at you and think you always have momentum. You feel, from day one to the time you shut the rebuttal down. Was there a time in this case where you really felt like we were there, we got it? You felt something inside that you just knew you were going to win this case?
I was fired up from the beginning. Knowing what happened to this young man, a 25-year-old, and having, permanent, irreversible damage to his penis, having a penis that is now smaller, shorter, with less girth, permanently scarred internally such that he can't have normal erections or maintain erections, and a penis that now, when he touches it in any way, or if a partner touches it in any way, it's pain instead of pleasure. That's a young man that deserves justice. So we were all fired up to go get this young man some justice.
Thanks for listening to Brutal Honesty. If you enjoyed this episode, please share it with others, post about it on social media, or leave a review on Apple Podcasts. To catch all the latest from Nick, you can follow him on Instagram and YouTube at Jury Trial Lawyer, and sign up for events at trialbyhuman.com.